Hi, my name is Heather Hulit. I am the Director of Client Advocacy at Christian Legal Clinics of Philadelphia, and I'm here to teach you about expungements so that when you get your next client who has criminal records and wants to talk about expungements, you know exactly how to handle it. All right, let's get started. The first thing we're going to do is start with PowerPoint. That's what we do. All right, so when we use the word expungements, we're actually, it's actually not the right term. I'm trying to get used to saying the term record clearing because record clearing is a lot more than expungements now. It also involves limited access sealing, which we do quite a bit of. So why the topic is important is because we could guess at this, but records create barriers for a lot of our clients. They create barriers with employment, which we would guess, but they also create barriers with housing. Landlords look up your records. And they also do in the way of public benefits. I mean, we hear a million stories, right? The one guy who just started working maybe a couple months ago and is finally on the up and up. He'd gotten offered a job as an insurance salesman. They saw a record from 7 years ago. And the private background check company they were using misconstrued his record. So they read it. You have your preliminary hearing in municipal court, and you have your Court of Common Pleas docket. So his municipal court docket showed all these nasty looking, well, one nasty looking charging indecent exposure, so that looks bad. But then when you look at what happened in the higher court, all that was tossed. He came out with disorderly conduct, I think, something super low. However, the private background company spit that out, interpreted that as, oh, it's pending. These charges are pending. So the job was put on hold. So we have another guy, he's very single, his only case ever, but it was 3 or 4 years ago. It was a third degree misdemeanor, so it's pretty low. You can't do anything with it till 5 years has passed. So there's all these things. We have a lady we're trying to help get rid of a felony, her only case ever from 33 years ago, and it has defined her life. There's all these plans that she had, but at 18, she was on the block and got involved in a big fight. And that has defined her life. So it's going to work. You hear a lot of sad stories, but you'll hear some good ones. So records are pretty public, more public than I think people realize. We will, through this training, learn how to look people up, and you'll see their records. Records are stored with Pennsylvania State Police, with the FBI, with private background companies that pull from public records, and with this internet search that is public for all of Pennsylvania. Okay, so expungement is kind of the loose term we use for all kinds of record clearing, but it's really just one option. Expungement completely removes, wipes out, as if it never happened, the criminal history. It's as if you threw it in the fire, it never happened. So charges that result in non-convictions are always eligible, not just eligible, they are entitled to be expunged. You are entitled to have your acquittals, your dismissals, your not guilties expunged. Some convictions are entitled to be expunged. So your juvenile convictions, most of them, unless you're talking about murder, most juvenile convictions are expungible. Summary convictions for underage drinking. I've not had a client for this yet. And all other summary convictions when there's a 5-year period afterwards where you're free from conviction. And all the fines and fees are paid for that summary. Expungements require fines and fees to be paid. Convictions can also be expunged when a person's over 70 and has not been arrested for 10 years following the final release from probation. Not as helpful, but we do have a case, actually have 2 running. One of them, it was granted. The other one, the DA's consented, so it's likely to get granted at that hearing. One of them has a really chunky record from, 30, 40 years ago, but a lot. He called himself, him and his wife, they refer to themselves as Bonnie and Clyde. He is over 70, his convictions, whatever the grade of them, there's some felonies in there, there's some unpaid restitution, there's some unpaid fines. The DA's office filed a consent. Those will get expunged just because he's over 70. I have one guy with one single record from 1970. He is now over 70 years old. He has unpaid stuff related to it, and it is getting expunged, or the order has been signed so that it's expunged. Doesn't matter that he has unpaid stuff, he's over 70. Or if you have died, and not just died, but been dead for 3 years, you can also have those offenses expunged. Super helpful. Diversionary programs. So you'll see ARD a lot. ARD is usually ARD is for first-time offenders. It is offered by the DA's office. You kind of go through a program, which from what I understand is really paying a fee and having a probation officer visit you some minimal number of times and staying out of trouble for this period of time after your arrest. And then they tell you, and then it gets expunged. So people think it happens automatically. It does not, or it does now, but it didn't used to. These other diversionary programs you don't see as much. Project Dawn is related to prostitution. I've never seen it on a docket. I've never seen these other ones on a docket. They exist, but I don't know that you're going to see them so much. But you're going to get a completion letter. When you finish the program, you paid your fees, you did the class, you did the supervision, you get a letter. There's a number you can call if someone says, I swear I completed it. The docket looks like they completed it, but they don't have their letter. You will have to file that letter with your petition for expungement. All right, a partial expungement is like whiting out a docket. So a docket can contain both convictions and non-convictions. And when you're doing a partial expungement, you're whiting out the non-convictions. Why you'd want to do this is that you may have heard of upcharging. You'll see dockets where someone was charged with just the full house of things. And then you see the preliminary hearing, everything's held for court. You get to their common pleas docket, and most of it's tossed, and they have a conviction for disorderly conduct, simple assault, possession, something much lower, but they were charged with attempted murder and, manufacture and delivery, some bigger stuff. So for example, your criminal record shows these, this list of things: simple assault, ag assault, bad; attempted murder, really bad; possession with intent, pretty bad. After partial expungement, the criminal record shows the one conviction from that list: simple assault, much better, right? You could tell a story about that at a job interview, whereas it's hard to tell a story about attempted murder and all these other things. So just reducing the list. You do not have to pay fines and costs or restitution in order to receive partial expungement. One is because the record's not being entirely destroyed, the conviction is still there. And two, those fines and costs are related to the conviction, which you're not messing with. They're not related to the non-convictions. You are entitled to have non-convictions cleared off your record. All right, changes. 2018, a bunch of different groups across Pennsylvania have been advocating hard for opening up more ways for someone to clean up their record. The idea being, if someone has a record, like this lady we're trying to help with a pardon now, she has this one felony from when she was 18 years old. It's defined her whole life. So she's had very limited employment opportunities, got into college, didn't bother going because this happened the summer before she was supposed to go. And it would have blocked her from the type of work she was going to college for. So if she offends more because she had a barrier, right? So if we help people get rid of the records, the idea is that we would have less recidivism. However, you're balancing the need to public safety, right? There's some types of crimes that have high recidivism rates. Maybe we want to know about those. Maybe there's a reason for that to be public records. Maybe there's a reason they shouldn't have certain types of employment. We want employers to be able to see that. You can imagine, employers hiring somebody for security, and then you find out, oh, they have this whole, maybe we want to know that they have a lot of records for assault-related kinds of things. So as we talk about the exceptions, of which there are many, you'll kind of see this balancing act in play. But this is good news for our clients because it gives them, it makes the conversation longer than just conviction, sorry, goodbye, non-conviction, oh good, we could do something about that. There's a lot more nuance now, which makes it a little harder to analyze the cases, but it makes it so there's more ways to clear your record out. So this is good for our clients. Okay, so there's two parts. There's petition for limited access sealing, so filing a petition for a client. And then there's the automated piece where automatically, without the individual having to take any action, his non-conviction is off his record. His summary offense after 5 years is off his record. His lower second, third degree misdemeanors after a certain amount of time, off his record. So sealing, there's between sealing and expungement. Sealing hides your criminal convictions from the public and from private and commercial background check companies. So had this been in place for my one guy, his employer would have never seen these charges. Law enforcement can still see them. So if you're trying to get a gun, we have some clients looking for that. Sealing is not going to get rid of those offenses. So they're still going to be seen by law enforcement. They're going to be seen for licensing purposes. They're still going to be seen for if you're trying to be a police officer, if you need an FBI background check, still going to come up there. So automated limited access is you'll see the difference here. Automated will handle your summary offenses. It'll handle all of your expungable offenses in case you don't file that petition, because the burden is on you to file for expungement, which doesn't seem fair if you weren't convicted, but that's the way it's been, and it's the way it is in most states. The burden is on the person who was arrested and whose charge was dropped to then go back and clear his record at his cost, at his time, at his, no one's training you to do that when you walk out of court. You think it's just going to get handled. So you've got to take the time and the money to do that. Automated limited access gets at that problem in that it'll automatically seal those expungable offenses, your summaries and your expungable offenses, your non-convictions. It'll also seal your second degree and third degree misdemeanor convictions and ungraded offenses, which carry maximum sentence of no more than 2 years in prison. So essentially ungraded offenses where there's just an M on the docket that are sentenced or that have a maximum sentencing that are like something less than, it's a second degree misdemeanor or less. We'll talk about that more in a second. Limited access petition is broader. It covers, you would never file a petition for summary offenses and expungable offenses because you would file an expungement petition, but you could, it'd qualify, but you wouldn't actually do it in real life. You would file it for your first degree, second degree, and third degree offenses. So there's some level of discretion. A judge will consider it, right? It's not going to get automatically sealed, but now you can get it in front of a judge to consider sealing a first degree misdemeanor offense, as well as ungraded offenses that carry a maximum penalty of no more than 5 years. So what it's saying is for the docket to just say M, doing this for M, if the sentencing for that offense is no more than 5 years, so no more than what it would be as a first degree misdemeanor, you can petition for it. Okay, so this kind of helps you figure out what they're talking about when they say no more than this, no more of that. A first degree misdemeanor is a max of 5 years. Whoops. So this is when they're saying ungraded misdemeanor with no maximum sentencing, no more than X, you can see what they're getting at. You can see that they're maxing at first degree. They're not felonies. There's nothing you do about felonies. Those are still the untouchables in terms of record clearing. And so you see that when they're talking about a maximum sentence of no more than this, that, or the other, they're talking about this. So you'll get a copy of this PowerPoint. This will be accessible on our website because I find this chart helpful to analyze. Okay, so records that are automatically sealed, we won't spend long here. Second, third degree misdemeanors, expungable records. All right, for both the automatic sealing and the petition to seal, or rather automatic limited access sealing and petition for limited access sealing, the petitioner has to have been free from conviction for a period of 10 years. Summary offenses don't count. So for any offense punishable by 1 or more years of prison. So what it's saying is any offense higher than a summary counts. Any offense of a summary judgment in that 10-year period doesn't count, because remember, summaries are 90 days. Your next highest grade is a third degree misdemeanor. So if in the last 10 years, your guy has had a summary, he should still look at doing a limited access petition. If he's done more than a summary, then you have to start your 10 years from the date of that last conviction. So you're not going to be doing anything for automatic sealing, just be aware that it exists. Records for which you can file a petition. So this is for your petitioner, again, who has been conviction-free for 10 years, aside from summaries. We don't care about those. For these type of records, the first, second, third degree level offenses, or the ungraded offenses, which have sentencing that is no more than that of a first degree misdemeanor. So you may find yourself Googling the statute to see what the statute says about sentencing. You can also, sometimes you have to kind of figure it out from the docket. If the guy served 6 months for an assault, probably was a third degree misdemeanor and not a first degree misdemeanor. Okay, there's a lot of exceptions, and your exceptions fall into 2 categories. This is the balancing act. The one category is the types of offenses that can be sealed. they're offenses we don't want to seal. At a certain grade, we want them to be seen. That's the policy of the legislation here. And then there's also exceptions related to the type of petitioner. So maybe that record itself would qualify, but this particular petitioner, his or her record as a whole makes them ineligible for limited access sealing. So don't be intimidated by all the language. We'll break it down. If the person in front of you has convictions for assault, murder, kidnapping, things in this category of danger to the person, terroristic threats also falls in there. If they have categories related, if they have offenses related to incest, don't see that a lot. If they have offenses related to firearms, right? We see that quite a bit, carrying without a license. If they have offenses related to Megan's Law, then these are the ones where you pause. You're not gonna be able to give them a straight answer in the consult. You're gonna say something like, we're gonna analyze this more and get back to you, because you're gonna spend some time charting this out. All right, so you got to look at the type of offense, but also the sentencing, the grading of that offense. So a conviction for an offense punishable by more than 2 years in prison. So that is I think I have that wrong. I think it's M2 or greater. For either, I'm sorry, maybe it's M1 or greater, because it's more than 2 years. For either committing, conspiring, or soliciting to commit any of the following will not qualify for limited access. So in short, an M1 or greater for any of these types of offenses in these sections is not going to be sealable. So to break that down more, you have a 20-year-old conviction for carrying a gun without a license listed on the docket as an M1. That is not going to be sealable because of the grading. So it's that type of offense, a gun offense, firearm offense, and it's graded as an M1. You have a guy with a 1991 conviction for simple assault. No grade on the docket, but he only served 1 year in prison. Simple assaults in that category of danger to the person. However, the grading is so low that it should still qualify for limited access. So here down at the bottom again, M1 is 2 to 5 years. M2 is 1 to 2 years, right? So if the max is 2 years, you're still good. They're worried about things that are more than 2 years because that puts it in the first degree misdemeanor category. You're probably not going to do that whole analysis while the person's in front of you. I wouldn't take that pressure. I would just take note of it, and you're going to analyze that after they're gone. But you should raise it as a possibility for them. Like, there's some stuff, and you're going to take this through. There's a lot of exceptions. We've got to really, if somebody with a chunky record, especially, you're probably going to need to analyze that after the consult and get back to them. Okay, now we're going to talk about the eligible petitioner. So their criminal histories as a whole may make them ineligible to pursue limited access, even if the offense itself they're looking to seal would otherwise qualify. So, like I said, these look at the types of offenses you've been convicted of and how many offenses of a certain severity you've been convicted of. All right. So don't get intimidated. This is very doable. For automatic sealing, you can't qualify if you have these convictions on your record, no matter how old. For petition for limited access, you can't qualify if you have these types of convictions in the last 20 years. So again, petition allows the judge to consider it. Automated sealing is not going to consider it. A judge has to take a look at it for these. All right. Indecent exposure, sexual intercourse with an animal, registration requirements like Megan's Law. I've never seen some of these, but you can tell what the legislator cared about. Related to weapons or implements for escape, related to abuse of a corpse, related to paramilitary training. I had to look that one up. You're not going to see these much, but if these are on someone's record, pause, okay? They're not going to qualify if they have them in the last 20 years, even for a petition. All right, the differences between the exceptions for automated versus a petition has to do with time. So automated limited access is not gonna do anything for you if you have a felony ever. So the people we file petitions on typically have a felony, and that's why we have to file a petition. Petition for limited access cares if you have a felony within the last 20 years. Oops. But if it's not within the last 20 years, you're good, you're safe. If you have over your lifetime, 2 or more offenses punishable by imprisonment of more than 2 years. So 2 or more offenses of a first degree misdemeanor or greater, all right? Over your lifetime, automatic sealing is not going to touch you. That's a lot of people it's not going to touch. However, petition for limited access will still, you can still be considered if within the last, as long as it's not been within the last 15 years. So I have a guy who has a pretty chunky criminal history. And I mean, it was a pretty long analysis to figure out whether he would squeeze through these exceptions. So he like barely made it with this one, the 15-year look back. He did have several M1s, but they weren't within the last 15 years. They were spread out. Over lifetime for your automated of having 4 or more offenses punishable by imprisonment of 2 or more years over your lifetime. Within the for your petition, it's looking at the last 20 years. If within the last 20 years, you had 4 or more offenses punishable by 2 or more years. So again, your first degree misdemeanor. So you can see here, petition will ask us to look at the last 20 years about those convictions on that previous page, these types of convictions. It's looking at those within the last 20 years. Automated, it cares about those types of convictions over your lifetime. Okay, who can see a sealed record? Only law enforcement, state licensing agencies can access a sealed record. We mentioned that earlier, but it's worth reiterating. What is also worth reiterating, because this is the thing that clients really want to hear, your record that has been sealed, you do not have to report that record to anyone except law enforcement. So if I'm applying for a license to carry a firearm, I got to report it. If I am applying for a job, if I'm applying for school, I have to report it. That's if it's sealed or expunged. If you have a record that has been expunged, you don't have to report that to anyone because it is as if it did not happen. It's like having a judgment vacated. Legally, it never happened. All right, important warning, if you have someone in front of you who is not a United States citizen, they should not pursue any of these for reasons that are too complicated to explain, having to do with the, you just shouldn't do it. It causes a problem when you're trying to gather your histories for your immigration process. You won't be able to because you've had that thing expunged or sealed, and it becomes problematic. All right, so we're going to, when you have a client in front of you, maybe you have a law student or a law clerk doing this for you, which is awesome. They'll click on this link, they'll enter in the client's name, their date of birth, and now you have to put in like the beginning of the search period. So I always put in like 1920, and the end date, which I always put today. And then you see what comes up. A list of cases will appear if the individual has a criminal history. We'll kind of go over the list with your client, and then you'll take down in your notes the docket numbers of each case and how that case, how the offenses in that case ended up. So I'm going to show you an example of a criminal docket. So give me a moment. I'm going to unshare this and we're going to share something else. So when you get someone's docket, sometimes people have never seen their docket. So sometimes you might find yourself going over docket through screen sharing. If you're doing this virtually, showing someone their docket and explaining what it means is sometimes really helpful. So up here, you'll have your arrest date, which police department we're talking about. You'll have the judges that touch the case, the different court. So when you get an expungement on here, you'll see your expungement hearing date up here at the bottom. Like this one shows my motion petition for expungement. But all the different courtroom dates will be listed up here. Bail information will be there, the charges and their outcomes. So this was the only charge here, harassment. The offense date is here. And then if you scroll down here, you can see how it ended up. It ended up with a guilty plea, and it shows you that it's a misdemeanor of 3rd degree. So we know that this will probably be sealable because it's such a low grade. Okay, and then the other thing that you're going to want to look at is fines and fees. So for sealing, remember, we don't care about fines and fees, but we do care about restitution. So we're going to talk about that. Fines and fees are always down here. You have to put it in your petition. So you're going to be rolling down here if you're writing a petition anyway. Down here, you see there's no restitution. So if you're talking to this client and this is all they have, they qualify for limited access. They already did a partial expungement to clear out the non-convictions. That's why you only see the one charge. So this is what a redacted or partially expunged docket looks like. It shows just the conviction. So there's no restitution here. This person can proceed to have this sealed even though there's these unpaid costs and fees. All right, now we're going to go back to our PowerPoint. All right, so if you're looking at a docket, the difference here, I want to show you what this looks like because I messed this up recently. So it's fresh in my mind. You see on this docket, cost of fees is here, but then there's this other line, restitution. This individual will be able to file a petition to partially expunge any non-convictions on this docket, but they will not be able to seal their convictions with the unpaid restitution. Okay. To deal with unpaid restitution, you can call this number to see about a payment plan. That is also the same number you'd call to try to do a payment plan for your cost and fees because you're trying to expunge something, be it your cost and fees. So if you have a summary, granted, they're not usually going to be that high, but whatever. If you're going to expunge it, you got to take care of cost and fees. If you're expunging a conviction, you have to handle cost and fees. If you're expunging a non-conviction, you're entitled to that. And restitution, you have to pay that to get a sealing. So sometimes you do that search and nothing comes up. We had a guy's last name where his last name had an E at the end, and it wasn't recorded that way. So the docket, we didn't find him. And then we looked up his co-defendant and then we found him because it turns out his last name was misspelled. So sometimes you can figure it out and you can still find the record. Sometimes you have to have them fill out a access and review. They can do it. You can send them the link. They can do it. They can print it off and mail it with print out a money order. Or if they can't print it, they can send us the money order. We'll print it and mail it out and request it on their behalf. It has to do with just mistakes and errors in the record. The filing fee for a petition to expunge or to seal is $147. Everything we file, we do with an informal papyrus. A lot of our clients will qualify for this. The form and the documentation requirements vary county to county. Some counties want you to, some counties want you to print off your bank statements and all kinds of stuff. Philadelphia, thankfully, if there's an attorney on it, you're just writing a letter, they accept it. It's a lot easier. So it's one of those things, if you're dealing in different counties, you're going to call and ask before you file. So I'm hoping that this makes you just a smidge more comfortable handling these types of consults. You never have to have the full answer with somebody while they're in the room. So if you run into these longer histories, you see some of the categories of convictions that you remember have exceptions, you can pause. You can say, we'll get back to you. Doctors do it all the time. Lawyers do it all the time. It's totally fine not to have a final answer. You'd rather leave somebody with some hope, but you don't want to overpuff them and be like, we can definitely do this, clear it out. And then they get a call a few days later being like, actually, no. So it's always good to hold your judgment, hold your final answer for later, but you want to give them a sense of what they might qualify for, what we're going to explore, what we're going to look at. If you have questions, that's what I'm here for. So you'll always be able to reach back and ask me questions during this consults and after this consults. Good luck.